All right, ladies and gents, welcome to Civil Law and Juvenile Law. We are going to stop at Civil Law today and continue on Juvenile Law in another lesson. But we just finished talking about in a previous lesson the criminal law process. So how you get from probable cause to having a strong chance that someone has broken the law, all the way to sentencing of that person for whatever crime they were proven to have committed. All right, so now we talk about civil law, and we're going to have to switch gears just a little bit. So remember, if we think back to talking about civil law the past few lessons, civil law is when you have a dispute between two parties or an issue between two parties because a contract has been broken at some point. Remember, the two sides of a civil case are the plaintiff instead of the defendant and the prosecutor. The plaintiff is the one who's on offense. They are making the complaint. All right? And the defendant is the one who's on defense, and they are being accused of wrongdoing and breaking a contract. All right, so what does civil law look like? What are some examples? You can write these down. So divorce, custody disputes, money issues, who gets custody of your child, who gets what stuff if the two of you decide that you do not want to be married anymore. Tort law, I know this is very small. This means that someone has either been abused or neglected and suffered injuries. So like we discussed very briefly in types of law, tort law is a type of, or a subcategory of civil law, and that means that someone has been harmed, abused, or neglected in some way. So if you see commercials for lawyers, if your granny is in a nursing home and you think that your granny has been the subject of abuse or neglect, you can call this particular lawyer, and they work exclusively in this type of law, so within a tort case. All right, and how is civil law handled? You can either handle it in court or out of court, and if you handle it in court, there's a similar process to criminal law. But there are a few less steps, and it looks a little different. It's not quite as dramatic, and it's not the Law and Order type stuff that you're thinking about. And you can settle out of court in two different ways, and we'll talk about that towards the end of our lesson. So first, let's begin with ways to settle in court, and there are 6 major steps. The first of which is a complaint, and we're going to number these and label them in the graphic organizer just like we did for criminal law on your note sheet. So number 1 is complaining. All right, we can't have a civil case if nobody's upset about anything. All right, so a plaintiff, the person who is on offense, issues a formal complaint to the defendant for damages or compensation. So basically money from injuries or debts. Let's say, for example, we use the hot coffee case. You've probably heard the phrase, spill a cup of coffee, make $1 million. It is not that simple, and that is not actually how the case came to be, and that is not the actual detail of the case. But I digress. So let's say, for example, this lady, this is based off of a real case, she's like 85 years old, she just wants some coffee one morning, and she's driving in the car with her son, and they decide to stop at McDonald's for some coffee. All right, the son goes inside, he gets some coffee for himself and for his mother and puts it in those little weird egg crate looking carrier things to carry out to the car. She's older, so her hands are not the most steady. She takes it out of the carrier, begins to drink it, and spills it over her lap first because the cup is so hot that she can't even hold it, and she ends up in the hospital with 3rd-degree burns. Now, she's not just going to let it go. She and her son get together with their attorneys, and they decide that they are going to sue McDonald's for monetary damages and for her injuries for her 3rd-degree burns. That's a complaint. Number 2, you get a summons. All right, the plaintiff issues through the court a formal request for the defendant to come to court and settle the dispute. So basically, this is a get your tail to court. We gonna talk about this. They usually call this being served. So if you've seen anything on Law and Order where someone has like knocked on their door and you're like, "Hello, can I help you?" and they're like, "Yeah, you just got served," and they hand them a stack of folders, or they hand them a large, like yellowish looking envelope, that is a summons. Basically, you are being told that you have to come to court and defend yourself or your actions. Number 3 is a response. So the defendant is allowed to clap back at this person if they get a summons to court. So the defendant and, oh my gosh, I can't believe I just put his. The defendant and his or her attorney file an answer, and they make what's called a motion. right, number 4, now that the plaintiff has said their little part and the defendant has had their opportunity to say their part, then the two of them go in front of a judge. All right, so the plaintiff and the defendant both file pleadings documents, and they say, I would like to plead not guilty to this. I would like to plead that this is some nonsense, all right, but in a more formal legal language. All right, and the complaint and the answer are collected together. So basically this is just a formal set of, here's what's wrong, here's what I would like you to do to fix what's wrong that you've done, defendant. And they say, that's false, I did not do this, or my company did not do this, and we're not paying you a thing. Alright, so your formal statement of what you want to occur and their formal statement of their response gets filed together. And then number 5, if you decide to go this far, you go to trial. So the plaintiff presents evidence to the judge or the jury, well, judge and the jury, and the defense presents their case. So the two of you fight back and forth. Another good example of this would be a case where, let's say, a company is creating some kind of processed good, and in the meantime, their little factory is by a river, and their factory has messed with the water quality in the river so that people can't drink the water. All right, so they might, the plaintiff might say, well, you have poisoned our water, people are getting sick, and the defense says, no, I didn't do that, there's no evidence, blah, 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 and they present their case. All right, and then number 6, as with any other trial in the criminal law system, the civil law system is very similar, and you reach a verdict. Now, the jury decides who wins. This is not about guilty or not guilty. That has nothing to do with this. All right, so the verdict is a decision on who wins the case. So is it the plaintiff or is it the defendant? Okay, so if the plaintiff wins, the defense has to pay money to fix the problem that they created. And if the defense wins, the case is over and we all go home. All right, so typically you don't see civil court or you don't see cases that reached civil court. Usually somebody says, like, I'm going to sue you. Instead of going through that whole 6-step process, they just decide to settle out of court. All right, and there are 2 ways to do this. So like the two of you meet up at your lawyer's office, at your place of business, at your home, and you and whoever you have an issue with are going to settle the dispute without the assistance of a courtroom and a judge. All right, so now the first way to do this is called arbitration. All right, and this is when 2 parties, so you and another person or one company and another, something to that effect, 2 parties decide to have one or more people settle the dispute in private. Okay, so the 2 of you decide that you cannot come to a conclusion, just the 2 of you together. You're going to be too upset, you're going to be too mad. You need a ref. You need a third person to tell both of you to stay in your lane and to calm you down if you get upset. And you need the third person to help you come to a decision. And then both of you have to agree to follow whatever resolution is made. So when this word resolution, all right, so when the 2 of you decide on how to fix the problem, you both have to agree on this. So we've had some questions in the last few lessons about Judge Judy, Judge Mathis, Judge Brown, and if they're actually judges. They do hold the title of the Honorable Judge Judy, whatever her last name is, or the Honorable Judge Brown, the Honorable Judge Mathis. At one point in time, they went to law school, they passed what's called the bar exam, and they were what's called a sitting judge. So they served their time as a judge that was employed by either the city, the county, or the state government, and now they are arbitrators. So when you go on Judge Judy or Judge Mathis or Judge Brown, if Judge Judy tells you you have to do something at the end of the case, even if they have their little exit interview and they get in front of the camera and they talk all big, bad, and ferocious, like, I'm not going to do what she says. Yes, you are, because when you sign up to be on Judge Judy, you sign a legally binding agreement that says that whatever solution that the 2 of you and Judge Judy make together, you must abide by. All right, so she or Judge Mathis or Brown would be the ref. Right, they are the third party. Mediation is the other way to settle a civil case out of court. All right, and this is when you and your lawyer get together in a room with the other person and their lawyer, and the 2 of you trust each other to A, not act a fool, and B, abide by whatever agreement that you follow. Now, there is no legally binding document, as there is with Judge Judy or whatever, There is no legally binding document that says that you have to follow this agreement, but most of the time, I'd say probably about 85 to 90% of the time, unless people want to end up going to court anyway, they will do what people ask them to do. Okay, so that's how you settle out of court. All right, and this has been Civil Law.